I'd always get right back up, never worry, 'cause I got a million reasons to keep holding on. Yeah, I got all that it takes to win and overcome. What I got is just a feeling, but it's so strong. It goes on and on and on. There's something going on inside of me. I feel it growing stronger every beat. I never just believe in what I see, 'cause I can feel the energy.
Happy Thursday. It is I, Gordon Firemark, the Upside Down podcast lawyer, and it is, as I do every Thursday, time for the Podcast Lawyer Live. And I'm going to be answering a few common questions that I've gotten in the last week or two, and anything that you are, if you're live watching, I would love to hear from you with your questions as well. And yeah, it's been an interesting week. I had an interesting experience. This is not, strictly speaking, lawyer stuff, but my main podcast is called the Entertainment Law Update Podcast. And earlier this week, I recorded our monthly episode with my co-host, and we'd been talking about what could we do with Clubhouse. And so I decided to, everything's running through a Rodecaster Pro, so it's easy enough to plug in the iPad and log on to Clubhouse. And we did a simulcast of our live recording session while on Clubhouse as we did our show. So we, just said hello to everybody, and then we started recording. And we had people dropping in and out, and it was kind of fun. Don't know if that's something we would do again, but I would love to know from you if you use Clubhouse in that way or another way as an adjunct to your podcast. The other thing we're thinking about doing is hosting some listener meetups in Clubhouse from time to time, and maybe do sessions where we just do a sort of a deep dive, get some other lawyers to come in as well and talk about a particular topic in a little greater depth than we're actually able to do on our normal podcast rundown timeline. So had a little fun with that, and I just thought I'd share that with you and ask for your input and advice about how you using Clubhouse. And also thinking about maybe doing live video while we record our show. I don't know, that means a lot more production, and my co-host would feel obliged to put on her makeup and those kinds of things. So we'll see. But in any event, I do have a few questions to share with the. I got to find my. I pushed the wrong button and it went wonky on me. So I apologize for that. Oh, I see. Yeah, I see what it is. Okay, so anyway, let me get to the first question. The first question was, we had someone reach out to us about a podcast transcript service. And they're asking, as someone with their finger on the pulse of podcasting, I was wondering, have you seen transcripts to be beneficial for podcast listeners? And I will tell you, my answer is I don't know so much whether it's beneficial, for the show, for the podcast, but I think it is definitely good for your listeners, especially those who are hearing impaired or maybe cognitively challenged, some other kinds of things. And I think, I'm reading the tea leaves here, but last August I did a presentation to the Podcast Movement conference about accessibility of podcasts. And I think, I'm reading the tea leaves here, but I'm going to say transcripts and or captioning are going to become a necessary component of podcasting, at least for certain podcasts on certain platforms, certainly the bigger ones. They're getting sued over this stuff already, and I think that the settlements in those lawsuits are going to call for transcripts or captions wherever possible. They may be dismissed, I don't know. But under the Americans with Disabilities Act, the law says we have a duty to make our public-facing stuff, our products and services, accessible for hearing impaired persons. So there's questions about, well, are we a public-facing? Are we a place of public accommodation if we're a podcast? And the law goes back and forth depending on where you are about whether a website is a public accommodation or not. But it's the right thing to do anyway. Now, the lawsuits right now are against the big players, Spotify and Gimlet, of course, which is owned by Spotify, and I think Pandora and iHeart are also in the crosshairs of these kinds of things. So these lawsuits are underway against these big players, but they're the ones that are going to settle these cases, and that's going to set the standard that we all have to follow. So one of my messages to you is, hey, let's pay attention. Let's start talking about this and see if we can establish some standards in the industry ourselves as a matter of course, as a practical de facto standard, so that those lawsuits don't have the effect of forcing us into something that's more complicated or expensive or something like that for us. So should you do transcripts? I think the answer is yes. I've started doing it for my own show. We have an automated system where I upload the file. Actually, it's a really cool setup. You can upload the file to Auphonic, and I have it do my audio, sweetening, noise leveling, noise removals and leveling and those kinds of things. And before it outputs the file to Libsyn, one of my shows is on Libsyn, one of my shows is on Blueberry. I haven't tried the others, but I'm sure they all can be output. Once it sends the file over there, it also is sending it for a speech recognition that turns it into a transcript. And that system, that doesn't cost anything, it's free, I think up to a certain number of transcripts per month, it outputs it as a HTML file, so we can actually post that as a page, a separate transcript page on our website, which is great for SEO. We can also, we get the text file. We also get a captions file and a PDF. So we're able to output it in all those different formats and use it as a transcript that way. Now, it's a machine transcript, so it's not perfect. And I don't think the law is ever going to require we have to have a perfect transcription. If your audience can get fundamentally the gist of what the conversation is and so on, I think they can't say that it's an unreasonable accommodation. The bigger players may have to do more, but for right now, I think that's where we are. So I think it's beneficial from the standpoint of, hey, we're serving a broader community. And if you have a few hard of hearing, hearing impaired, cognitively impaired, whatever, folks that can benefit from reading your content, and it doesn't have to cost you a lot, why wouldn't you do it? Try to set up automations and systems or get a VA to help out with these things. We don't have to do it all ourselves. We don't have to incur great expense to make these things happen. So I say, let's get out and do it. All right, my next question that came in was from someone in my group, the Legit Podcast Pro group. They said, I'm looking to start a podcast tour in which I dedicate a couple of months to just being a guest on other podcasts. What are some of the things I should be aware of before agreeing to be on someone's podcast, if anything? And this is a great question. My first answer to this was really there's not really that much to worry about. I mean, you want to listen, of course, listen to the show and make sure it's a good fit and make sure that they're not doing anything objectionable. You can tell a lot about how they'll treat you by how they treat their other guests. And so that's step one. Is the content that they normally carry similar and cool with the kind of content you are comfortable with? And if it's a good fit, then that's a great start. If it's something you object to, have a conversation or just say no. Are they going to have you sign a release is another question. The release is a good thing because it really protects everybody by clarifying the nature of the relationship so there are no misunderstandings and misapprehensions about who gets what kind of thing. Anything that you don't like or disagree with in the release is something you should have a conversation with them about. They may be willing to strike it out. They may be willing to explain to you why they need it, and you may be satisfied with that. And again, how they've treated their prior guests and how they treat you will be much the same in most instances. But don't expect that you'll have rights of approval or pre-publication review, or that you'll be compensated, or that you'll have a right to have it taken down later. All of those kinds of things are the things that the release is there to protect against. And look, if you will get a pre-publication review, the release should say so. Now, there's a case going on right now where there was a release. This is the Libel case being brought by a woman who was a lawyer involved in Charles Harrelson's murder trial back in 1979. She was recently interviewed for a podcast, interviewed for 90 minutes by the host and producer of the podcast, without her ever being told that two of Harrelson's sons, not Woody Harrelson the actor, but his two brothers, were involved in the podcast as executive producers and in other regards. And she says she wouldn't have participated if she had known that they were involved in the production team. Now, she signed a release, and she's claiming that that release was obtained by fraud because they didn't tell her that the Harrelson brothers were part of the production team of the show. She didn't realize. And she's upset because they took this 90-minute interview she gave and they used 5 minutes of stuff, chopping it up in such a way that makes her out to have been somehow, I don't know whether deceptive or complicit in framing and setting up Charles Harrelson for this murder of this federal judge. We'll see what happens. I don't think she's going to succeed on that fraud claim, but it is the kind of thing you want to be aware of. If you're asking people to sign documents, they've got to have all the material information. If you're hiding something from them, especially if you're actively concealing something, that's a point to be concerned about. So that was something we talked about on my podcast just the other day, and I found it pretty interesting. So another question that came in, by the way, if you're watching live and you have a question, go ahead and drop it in the comments and say hello. Say hello anyway. I'd love to know who's watching and have a little conversation with you. But next question: if I want to read, what if I want to read from a book? I understand all about the music and video and stuff like that, but what if I want to read from a book? Is that a copyright issue also? And this particular person was saying, for example, if I wanted to read Edgar Allan Poe's *The Raven* at Halloween, would I have any issues? And so the short answer is, look, reading from books, generally not a good idea. Books are indeed covered and protected by copyright, just like songs and recordings and podcast episodes and films and poems and sculptures and paintings. And a book is a work of authorship, so it is entitled to copyright protection from the moment it is created for a period of time. Now, what's interesting is that Edgar Allan Poe's work is old enough that it has fallen into the public domain. The public domain means it's no longer covered or protected by copyright law. So that opens me up to talking very quickly about how long copyright protection lasts. We're going to start with copyrights on works created since January 1st of 1978. So anything created in the last, 43, 44 years, no, it's more than that, 50 years or so. Anything created basically, in the last 50 years, the protection of the copyright lasts for the life of the author plus 70 years. And 70 years after that person passes is when the work will fall into the public domain and be available for anybody to use. If the work was created by a company as a work made for hire, by a corporation or an entity of some sort, it's 120 years. So from the day it was published. So good long time. Now, works that were written or created prior to 1978. So that January 1st, 1978 is the operative date of the most current Copyright Act, the 1976 Copyright Act. But works created prior to that were under the 1909 Copyright Act. And there, the term of protection was originally 28 years. And then there was a renewal term of an additional 28 years. So that's 56 years. But then when Congress started working on a new copyright law, they added an extra 19 years to take it out to a total of 75 years. And then in 2001, there was a Copyright Term Extension Act, and that extended everything from life plus 50 to life plus 70, and now the 75-year term for those older works became 95 years. So if you count backwards from today, here we are in 2021, 95 years ago is 1926. So anything created prior to 1926 is in the public domain, fair game for you to use. And Edgar Allan Poe's work falls into that category. Now, what's troubling and challenging is that there are some things that were created sort of, bodies of work that were created bridging that year. Sherlock Holmes being one of them. And the Sherlock Holmes estate has been very aggressive in going after people who are using some of the earlier works of Conan Doyle that are now in the public domain, because they're claiming that elements of the character of Sherlock Holmes were developed after that. And so certain of those original components may still be covered by copyright. They had a case going against Netflix over the Enola Holmes movie that came out, I guess, last summer. I can't tell you exactly how that wound up, but it went on for quite a while. I think it may have settled, but there you go. So be a little cautious about things that were created around then, especially if it was part of a series or something like that. Now we're really getting into the weeds. All right, next question. This one, it comes up from time to time, so I just want to raise the issue. Oh, by the way, hi, Craig, from rainy, stormy Chattanooga. It's cold and threatening to rain here in the LA area as well. So far, no rain today, but I don't know what's going to happen overnight, but I'm sorry that you're experiencing the gloom. But the good news is there will be sunshine around the corner. So there we go. And it's spring, right? So there you go. All right, so the next question, photos on a website. The person writes in saying, I had some photos illustrating an episode of my podcast, which was based on a historical discussion or event, and I used these photos that I got from a historical textbook that I was using to create the episode. And I was contacted by a so-called rights management company with a demand for several $1,000s. What do I do? I'm paraphrasing the question a little bit. I'll come back to your question in a second, Craig. So first off, what do you do if you get that notice saying, hey, you've got photos on your website that are infringing our copyrights? First thing, take those things down. Just get them down. The fact that you take it down is not really going to be admissible as evidence of any wrongdoing or an admission or anything like that. But it gets it off of there just in case there's a finding that you're doing something wrong. The shorter the time, the better that it happens. Okay, so that's number one. Next up, do not respond to them until you get some legal advice about your situation. Yeah, you're gonna have to probably hire somebody to review the whole situation. Maybe you can get someone to give you a free consultation. I do that sometimes, to at least give you a sense of things. But look, everything that you write or say in response to these kinds of demands or cease and desist letters or whatever will be used as evidence against you. And it's very easy to inadvertently admit something you shouldn't admit. And so the answer is just don't say or do or respond to anything until you've gotten someone on your team who knows this stuff and can help. Now, number 3, don't panic about this. This is not the end of the world. They're asking for a bunch of thousands of dollars, but can they really get it? Good question. They've got a lot to prove in order to win a lawsuit against you. If they've chosen not to do a DMCA takedown, which would get it out of there right away, you've taken it down, and so the damage has stopped, all right? But they have to prove several elements. First, they have to prove that they actually own the work in question, and there's some places, some jurisdictions where ownership is required. It's not just having a license or a right to sue. They actually have to have the ownership of that copyright in order to bring a suit. So if this group or organization is contacting you, the first thing they have to prove is that they are representing the owner, or that they themselves are the owner that is bringing this demand. And that ownership isn't always as easy to prove as you might think. Secondly, they have to prove that they've registered the copyright. Here in the United States, registration is not required in order to have protection under the copyright law. It is required in order to take advantage of using the courts in order to bring a lawsuit. So they've got to register. Registration is a long, time-consuming process. You file a form, you submit the application, and you pay your money, and you upload the copy that has to be, all that, and then you wait, and you wait. You have to have a certificate from the Copyright Office before you can go in and file your lawsuit in court. Now, there's ways to expedite it, but even then it takes a month or more from the date of registration. But more importantly, if the work wasn't registered prior to the infringement, or it wasn't registered within 3 months of the first time the work was published, then they can't get the statutory damages, the automatic damages. They can't get their attorney's fees if they sue you and win. And those attorney's fees in a copyright suit are significant. It's tens of thousands of dollars at the very least. So they can't get that unless the work was registered in a timely fashion. So they've got to prove when was it registered. And your lawyer will say, hey, send me a copy of the registration certificate so we can verify that you're the owner and that it was registered on time. And then, so assuming that they didn't have a registration, well, let's take the other way. Assume that they did have a proper registration in a timely way, then their damages range, the statutory damages, would range from $750 at the bottom end, maybe less if it's an innocent infringer kind of a defense, but call it $750 at the bottom end, up to about $30,000 at the top end, unless they can prove you're a willful infringer, like you're thumbing your nose at them and that kind of thing. Then it could go as much as 5 times more than that. But and the point is, on your website, it has to bear some relation to the actual nature of the damages. So posting a photo on a website for a few weeks or months before they catch it, it's going to be at the lower end of that number, if at all, right? But if they don't have that registration in place, they're not getting their attorney's fees and they're not getting those statutory damages. They would have to prove actual damages. So the next thing you want them to show you is, hey, you're asking for $7,000. Show me how that is a reasonable amount to represent your damages, given what you've licensed this photo to others for in the recent past. And if they can't show a licensing history and revenue stream from that photo, then they're not going to be able to collect very much in damages. Now, they will resist sending you this stuff, and your lawyer, that's why you want to bring a lawyer in, because hey, we're not going to continue these conversations unless you give us, show us yours and then we'll show you ours, kind of a thing. So if they can't prove their damages, that gives you a good idea that they're asking for a lot, but they're not going to collect it. This is where you then start constructing an offer of compromise. Let's face it, the photograph is copyrighted work. And if you didn't get a license from the owner or the management agency or whoever in order to use it, you have done something wrong, right? But it shouldn't be a financial millstone around your neck. So that bottom end of those statutory damages, $750, seems like a really good number to avoid the lawsuit, to avoid the back and forth, to settle it and resolve it. And if you want to put the image back up again, then you have to also negotiate a license going forward and all that. But you can make an offer. You could lowball it. You could go lower than $750 especially if they don't have a registration to show that it was registered before your infringement. Give them a few $100 for their trouble. If they file a lawsuit, they're going to spend a few $100 more. The lawyers are going to spend a lot of time, and most of these lawyers that are reaching out on behalf of these rights management folks are. They don't want to spend a lot of time. They want to settle it really quickly. So that's the approach: is make some kind of an offer and then negotiate a workout of things. It doesn't have to go all the way to trial. It doesn't have to go into litigation, but you don't want to come at it weak without information and be at their whim. Don't just cave in to their demand. Again, unless it's in the reasonable range. Now, I will say that. At the end of 2020, Congress passed a law and the president signed an update to things. It was part of that omnibus COVID relief package. There was something in there called the Case Act. The Case Act establishes a copyright small claims tribunal that will be starting at probably next year, addressing these kinds of claims in a low-cost forum that doesn't require a lot of legal wrangling, and like a small claims court. We have yet to see how that's going to play out and how it's going to be used. It's opt-in for everybody. So if the plaintiff says, I want to use this thing, and you say no, then, okay, we go to regular court. We go to big boy federal court. And, of course, that becomes more expensive. But if you're sure you're right, because it's fair use or because of some other defense to the Copyright Act, then maybe that makes some sense. So lots of stuff to unpack here, but Oh, there it is. Okay, so Craig, you had a question. Let me see if I can get it up on the screen here. All right. I think I know the answer, but if I wanted to use a very short, 20-second or less audio snippet from a YouTube video, and gave proper attribution and included a link to the full video in the show notes, would I still need the video owner's permission to use the audio, correct? By the way, I have not done this. Okay, Craig. Well, first of all, thanks for the disclaimer. So asking for a friend. The answer is maybe. Would you absolutely need their permission in order to do an audio snippet? The answer is not absolutely, no. In fact, I had this conversation with a prospective client just earlier today where the kind of thing that he's doing is very clearly a transformation of the nature of things. He's doing a critique and commentary of the videos that he's responding to. And you've seen, there are these reaction videos on YouTube. I'm sure you've probably seen where, someone will watch another video and then they'll react to it and tell you their thoughts or whatever. That kind of thing is probably going to fall under it's very likely that it could fall under fair use. Unfortunately, we can never say categorically because there are no rules of thumb when it comes to fair use. But that's the kind of thing we're using either a small amount of it or really responding to it with critique and commentary is probably okay. But if you're just using it because you love that music, you want to use, or you just love that funny line that they said, that may not be fair use because it's not a critical commentary kind of use. So it really does depend on the nature of what you're doing, the nature of the original, the nature of what you're doing, the amount and substantiality of what you've taken, and the impact on the market for or the value of the original. Those are the four fair use factors. And as I said, there's no rule of thumb. We have to do that analysis on each individual potential claim of infringement. When you use a piece, you got to go through that analysis and figure it out. So I hope that answers your question. I know the lawyers, it depends, is never very satisfying, but that's sort of why I'm here, as I want to make sure people understand that you can't just assume it's fair use or that it isn't fair use. You really do have to think it through and talk to somebody like me with the specifics if you're planning on doing it. That makes it hard because you want to produce the thing today, not wait a week for us to get together and talk it over, right? Anyway, thank you for your question, Craig. And I've been going for about a half hour now, so I think I know what I have to do. I have a little business to take care of. So let me just tell you about my free Facebook group called Legit Podcast Pro. And it is a group for talking about this kind of stuff, but also just how to become a professional, how to treat your podcast more professionally. And I would love to have you join me in that group. It's free. Come on over to Legit Podcast Pro here on Facebook. You can go to legitpodcastpro.com and join our mailing list as well, which is a great way for me to be in touch with you and let you know what's happening. And then you can join the group and become a part of all the fun. So I'm showing up in the Legit Podcast Pro group a couple of times a week, usually once on the weekend and once during the week, and just sharing more of these kinds of answers and things like that. So, any other questions? Anybody else want to say hello before I sign off? If not, I will do exactly that. I'm signing off, and I'll see you again next Thursday when the Podcast Lawyer goes live to answer your questions and share a little bit of insight. Thanks for watching.